Good day everyone. In this video, we are going to cover the very first chapter for CRG 660, which is Legal Framework for Corporate Secretaryship. Firstly, we will look at some laws and regulations affecting corporations specifically in Malaysia. Meanwhile, in the second part of this video, I will be explaining about the institutions which have the legal rights and responsibilities towards those laws.
As for the introduction, who is corporate secretary? What comes to your mind when you see the word secretary? If you're imagining someone who works in an office, writing letters, making phone calls, and arranging meetings for a person or for an organization, you are referring to a wrong person. By definition, a corporate secretary is an officer of a corporation who is responsible for the official documents of the corporation. Not only a corporate secretary is responsible for any statutory documents that need to be submitted to the Registrar of Companies, the secretary is expected to have a working knowledge of the Constitution and to apply that knowledge in a practical way to a variety of situations. Corporate secretary should have a good understanding of compliance systems and possible offenses to prevent unintentional breaches of the law. Zooming into a public listed company, corporate secretary needs to be aware of the framework of regulations for listed companies and the general ongoing requirements. Shareholders, potential investors and other stakeholders need to have a high degree of confidence that a listed company is properly run and fully complied with statutory obligations. So, in Malaysia, laws and regulations affecting corporations comprised of the Companies Act 2016, Securities Commission Act 1993, Bursa Malaysia listing requirement, as well as the policies and guidelines by the Securities Commission of Malaysia. We are going to have a look at each of this in details. Let's start with Companies Act 2016. This act comes into force on January 31, 2017, replacing the Companies Act 1965, which has been around for more than half a century. Companies Act 2016 is applicable to all types of companies, be it private, public and foreign companies operating in Malaysia. It governs almost every aspect of company law, including the power of Registrar of Company, ROC, filling of documents with the Registrar, incorporation of companies, constitution of company, the power of companies, as well as any matters related to shares and membership. Having said this, we could clearly see that the purposes of Companies Act are to enhance corporate governance across the organization by regulating the conducts and rights of everyone dealing with the company. Second, laws affecting corporation is the Securities Commission Act. As we all know, corporations and securities cannot be separated, as securities are tradable financial instruments used to raise capital in both public and private markets. If we have Companies Act 2016 to govern the companies, then Securities Commission Act 1993 focuses more on the securities law in Malaysia. This act establishes Securities Commission, SC. The purposes of this act are to regulate primary capital market and to set rules regarding corporate proposals. Examples of corporate proposals include proposals for a public company to offer for subscription of securities on a securities exchange, whether in Malaysia or outside Malaysia, a proposal to make a bonus issue, or a proposal to issue employee stock options, and many more. Next, we have Bursa Malaysia listing requirement. Listing requirements are a set of conditions which a corporation must meet before listing a security on one of the organized stock exchanges, such as the New York Stock Exchange, the London Stock Exchange, or the Tokyo Stock Exchange. And as for Malaysia, we have Bursa Malaysia. For example, to get listing in the main market, a company must demonstrate that it has achieved minimum profit track record or minimum size measured by market capitalization. Bursa Malaysia issues practice notes to ensure investors are well informed of their investments by enhancing disclosure requirements that need to be complied by the corporations. At the same time, these listing requirements are there to maintain highest standard of integrity, accountability, responsibility and corporate governance. Last but not least, corporations in Malaysia also need to observe policies and guidelines by the Securities Commission. The purposes of these policies and standards are to promote self-regulatory in the capital market and to accord greater flexibility and efficiency in the process of capital raising. For example, SC has issued the guidelines on the offering of equity and equity-linked securities under Section 377 of the Capital Markets and Services Act 2007 in considering proposals relating to issuance and offerings of equity and equity-linked securities, listings of companies and quotations of securities on the main board or second board of Bursa Malaysia Securities Berhad, and the acquisitions or disposals of assets which result in a significant change in the business direction or policy of companies listed on the main board or second board of Bursa Securities. By now, you should have some ideas on laws and regulations affecting the corporation in Malaysia. But you might be wondering about who are responsible in protecting those laws. Who are there to make sure the companies and their directors are compliant with all the regulations? So now, in the second part of this chapter, we are going to learn about the guardians of laws affecting corporations. Altogether, we have 4 organizations, namely Company Commission of Malaysia, SSM, Securities Commission of Malaysia, SC, Bursa Malaysia Securities Berhad, and Bank Negara Malaysia. First, let's look at SSM or Company Commission of Malaysia. SSM administers and enforces Companies Act, registration of business and all subsidiary legislation. Its CEO is the Registrar of Companies, ROC. The Commission has power to inspect, investigate and compound offences under relevant tax. Moving on to the next organization, we have SC. This commission is established under Securities Commission Act 1993 and serves as a central authority responsible for the regulation and development of the securities and futures industries in Malaysia. Not only SC has broad power to make and interpret rules, investigate and enforce the rules relating to securities law, the Commission also regulates the conduct of brokers, dealers and investment advisors. The next one is Bursa Malaysia Securities Berhad. It is an exchange holding company approved under Capital Market and Services Act 2007 with the objective to maintain an efficient, secure and active trading for investors. As we discussed in the first part of this video, Bursa Malaysia has power to govern the stock exchange, brokers, and companies participating in the Bursa Malaysia Stock Exchange through the listing requirement and practice notes. Finally, we have Central Bank of Malaysia, who reports to Ministry of Finance. The objective of Bank Negara is to safeguard monetary stability and maintaining a round financial system. As what a guardian is supposed to do, Bank Negara acts as a banker and advisor to the government. We are at the end of this video. By now, you should have some knowledge regarding the laws and regulations affecting the corporation in Malaysia as well as the guardians of those laws. Should you need further explanation on these, feel free to contact your lecturer. Thank you and I wish you all the best.